We will now move on to the second matter, and this is the people of the Virgin Islands in the interest of A.A.P. That is number 103, 2020. Johnny Christian, are you ready?
Good morning, Your Honor. Yes, I am. I'm ready to proceed.
Okay, do you wish to reserve any time for rebuttal?
I wish to reserve 5 minutes of rebuttal.
Okay, you may proceed.
May it please the court, good morning. My name is Adam Christian of Ogletree Deacons. I represent the appellant, the minor A.P., on this appeal. With respect to the posture and facts, they are largely undisputed. On or about May 26th of 2019, there was a multiple person brawl in the 10th Street area of St. Thomas. Some minors were injured. Most of the participants were minors. There may have been one or two young adults involved. A.P. was identified as someone who participated. He was charged. In the amended complaint, he faced 6 charges of delinquency, one of which would have been a felony crime if committed by an adult. The remainder were misdemeanors. The A.P. entered into a plea agreement with the government to count 3, simple assault and battery, aiding and abetting. The family court accepted the plea, and at the disposition hearing in February, put him on 6 months of probation with a host of provisions to follow. There was to be a review hearing in May that was not held until June 30th due to the COVID-19 pandemic. At that hearing, the court noted that A.P. had complied with several provisions of his probation, but had also not complied with several other provisions. The court also rejected at that time, over the objections of A.P., half of the community service hours that he had performed, as well as a letter regarding the ill effects of marijuana use. The court then set another hearing for August 18th. The A.P.'s probation was to expire on the 19th. As we prepared for the hearing, the Department of Human Services filed its report. I had moved for a continuance and then to have substitute counsel because I would have been off island. And then on August 17th of 2020, without any prior notice, the family court issued an opinion and order in which it determined that A.P. was in violation of his probation conditions, that further probation would not be fruitful, closed the case, and then transferred A.P. To the Department of Human Services for supervision. There was no deadline or any other guidelines with respect to that supervision. It must be remembered that A.P., as a minor, has certain liberty interests. He's free to come and go and act within the community as a free person, subject, of course, to the direction of his mother or other adults in his family. And his liberty interests can only be interfered with by the government, consistent with due process.
Well, let me ask you something, Attorney. You're really, as I'm trying to encapsulate what your disagreement is. And one of the things that I got are 2 things. One, there was no hearing after he tested positive and he was seen out on the street, and they want to perhaps hold a hearing. Well, a hearing should have been held. But more so, I get a distinct impression in reading a brief that you find it appalling and repugnant that he is transferred to human services for an indefinite period. There is no date of termination or anything at all. So I guess after he passed the age of the jurisdiction of the family court, that he might escape. But basically, am I correct that one of the underpinning of your argument is that error was committed when there was no hearing. The case is closed, which means that it's no longer in existence, basically, but he still has to report to the Department of Human Services.
Your Honor, that is correct, and that is for two reasons. One, as you point out, that it's for an indefinite period, and there are no other guidelines given to the Department of Human Services. So it essentially creates an administrative executive branch probation for which there's no authority in the Virgin Islands Code governing juvenile proceedings. Secondly, to the extent that what the court did was in effect continue a probation of some sort, the provisions of the code were not followed. So in either event, because of his liberty interests, the statutes have to be followed. The legislature has determined what process is due a juvenile under those circumstances.
What is involved in what you term as administrative probation?
Well, that's the problem, Your Honor. Because the family court did not follow what the Juvenile Proceedings Code provides in subchapter 3, chapter 201, title 5. It's not clear what sort of supervision is contemplated or for how long. The Juvenile Proceedings Code authorizes the court to supervise probation. It doesn't authorize the Department of Human Services to do any such thing. And I can find no other provision of the code governing human services that allows for this.
Did the court tell Human Services, well, you have to supervise the probation of this minor? Or did the court just say, look, this minor really needs some help. He needs some assistance. I don't think that keeping him on probation is going to help him any. So I'm going to place him under your quote unquote supervision. Isn't that what the court did? What is Human Services supposed to do?
Well, I believe that is what the court tried to do. But if there is some concern about the minor's, the conditions in which he's being raised, then the proper procedure is for the Department of Human Services to file a custody proceeding by a person in need of supervision proceeding, not for the court to close the juvenile proceeding, which is the sole basis on which A.P. was before the court, and then say, here, Human Services, I'm transferring him to you. With respect to juvenile delinquency proceedings, the only transfer provision is when a minor may be transferred from the family court to the criminal court to be processed as an adult. There's no provision allowing for the transfer of a juvenile from the court to the Department of Human Services for an unspecified supervision period or process. And that is the problem here.
Why are you arguing that the trial court needed to hold a hearing in this case if the trial court simply closed the case?
Because on the one hand, the family court closed the case, which ordinarily means that's it, everybody goes home. In this case, at the same time as it closed its case, it continued to impose supervision on the minor through the Department of Human Services, almost like an injunction that wasn't requested. And there is simply no basis on which for the court to do that. If the court, in effect, it is another form of probation. And the statute, section 2525, spells out how probation can be extended. It requires the Human Services Department or some other person with personal knowledge of violations of probation to file something with the court. It requires the Department of Justice to file a complaint. It requires a hearing at which the minor is represented by counsel. has the right to confront the authors of any report or any other complainants, and the right for cross-examination. And before the court can extend the probation or revoke probation, the violations must be found by clear and convincing evidence. None of that happened. This minor was, without any prior notice that this could possibly happen, placed under the supervision, unfettered supervision of the Department of Human Services. And that simply is not consistent with the Virgin Islands Code or principles of due process under the 14th Amendment or Section 3 of the Revised Organic Act. So what happened here is the minor's liberty rights were simply deprived. I would also point out that this also affects the mother's liberty rights to raise the child in any way, shape, or form that she sees fit. So I think that's another point that this court should consider. I believe my time has expired.
Thank you.
Thank you, Your Honors.
Senator Francisco?
Good morning, Justices. If it pleases the court, Assistant Attorney General Michael Francisco on behalf of the people of the Virgin Islands. Your Honors, we're here today to review the Family Court's disposition of appellant's case below. As presented in our brief, the Family Court was well within its authority to act as it did, and appellant was afforded appropriate due process under the law. The statutory language of family division procedure is both clear and comprehensive. Under 2521B3, the Family Court can, by order of protection, refer minors like A.A.P. to agencies like the Department of Human Services when helpful, both for their protection and that of the community. Additionally, the probation revocation procedures of Section 2525 do not apply here. Decisions like this are made in the best interest of the child, and by law command great deference in consideration of the unique role of the Family Court. The legislature, who instructed the Family Court to employ innovative strategies and leverage all available resources, intentionally authorized the court to issue protective orders as a condition of any other order, setting forth reasonable conditions of behavior separate of probation to be observed by any person before the court, minor or guardian alike. That power specifically includes the ability to order cooperation in good faith with an agency to which the child was referred by the court. And that is precisely what the court did here. After finding an extension of probation would be fruitless, the court discharged A.A.P. and referred him and his family to the Department of Human Services for protection and continued supervision. This was treatment, not sanction. Rather than just cooperate in good faith with DHS, as is undeniably in A.A.P.'s best interest, appellant has chosen once again to challenge authority. Since
what is the purpose of Section 2525 if you could simply modify it at any time under 2521B3?
Well, Your Honor, I'll say the Division of Family Procedure, the rules allow for 3 hearings: an adjudicatory hearing, a dispositional hearing, and a probation revocation hearing. As Attorney Christian pointed out, the probation revocation provisions have a whole slew of unique, due process aspects. A complaint must be filed by the DOJ, which it was not. None of those procedures were followed because they don't apply in this instance.
But why just because they weren't followed mean it didn't apply? I don't understand that logic. It seems to me that section was for a purpose. And if in fact he was violating the terms of his probation, that there should have been a complaint filed to modify, to revoke the probation, rather than simply, not conducting a hearing and simply closing the file and referring him to Human Services. So I just want to know, what is the purpose? I mean, did the legislature enact useless provisions, or,
Absolutely not, Your Honor. Probation revocation is a useful tool. It's a recourse for the DOJ in the event that a minor like A.A.P. is violating the terms of his probation. A.A.P. did in several instances.
Attorney, but you see, I think that, as I understand what what Judge Christian is saying, I'll call him judge once, a judge always a judge. But you see, when I read 5 VIC 25, it has an elaborate procedure for probation, revocation, and disposition. And one of the things that it involves is what Judge Christian had been saying: the proceeding to revoke probation should be commenced by the filing of a complaint. That's in subsection B. And then it goes on to talk about a whole hearing. So this thing of, well, I get a report from the Department of Human Services and I get some letters. He wrote a 2-page report on the effects of marijuana. He was seen out late at night and all these other things. But what I simply is that once you close the file and everything, wouldn't that trigger 2525? And I believe that that's one of the things that Judge Christian is talking about. He didn't have a hearing. Not only he indefinitely put over, but when you're going to do anything with that probation, 2525 is the pertinent section. Am I correct?
No, Your Honor, I'm sorry, you're incorrect. 2525 only applies in probation revocation, not any disposition of probation. The judge in the family court is allowed, under her discretion, to discharge A.A.P. without a further hearing. And I take exception at this idea that he wasn't given due process. Not only did he have an original dispositional hearing, he also had a mid-probation review hearing at which it came out not only was he still using marijuana, but he had not fulfilled the other terms of his probation. The judge is allowed wide latitude in situations like A.A.P's.
Yeah,
and I also take exception to the idea.
I agree that they have wide latitude, but it seems to me as if you're going to upend the entire basis of reason, because Judge Christian talked about the thing being some big thing, but I call it a royal rumble. That was a royal rumble that he was involved in, and he doesn't seem to be able to be taking orders from his mother or his grandfather or from anyone. But it seems to me as if that if you're going to have that drastic change of where you're going to close the case, no more proceedings in that case, but you're going to put him on an indefinite supervision under the Department of Human Services as a result of this case. As a result of this case, not because of something else that he did, but all of it emanated out of this single case.
Your Honor, I would just direct the court to look carefully at the statutes. Under 2521B3, the court is allowed to order an issue of protection. It's incorporated from the abuse and neglect statutes. Section 2552 provides the court can require cooperation in good faith. This is all for the benefit of A.A.P. I think that taking a step back, he is no longer conditioned to his probation term.
Well, let me ask you this. Are we moving from the original case in terms of, you said that he should have been, some complaint should be filed for a person in need of supervision?
No, Your Honor, PIN's proceedings were never initiated.
No, there was no PIN's petition filed. He is basically, this young man today is basically under the unbridled supervision of the Department of Human Services. Is he not?
He is not. He is not.
To review the Department of Human Services. How is the minor supposed to protect himself if his due process rights are violated by the Department of Human Services?
I think it's important that we remember Department of Human Services is there as an assistance in protecting not only him, but the community. As the court has already recognized, he was involved in a brutal brawl. And, this child needs further continued supervision, but probation in this instance, and I don't want to second guess the family court, but in her opinion, the judge determined that probation would be fruitless. And by law, she's allowed to order his cooperation, anyone that comes before the court, including his mother, his guardian, to volunteer.
Francisco, what do you call that kind of supervision? Administrative supervision? I mean, what happens with that kind of supervision?
Well, according to the law, if he if the court finds he did not cooperate in good faith with DHS, he could be brought back before the court under 2552B, Section 22524.
That's not an extension of the probation.
It's not an extension. I don't know. Extension of probation is very clear. Number one, the terms of his original probation would still apply. They do not. The court very clearly closed his case and ordered simply that he cooperate with DHS, his mother cooperate with them for his own benefit. In fact, there might be a standing issue, and standing is a jurisdictional requirement that can be reviewed at all stages of litigation. I defy Mr. Christian to tell me, Attorney Christian, to say what the detriment to A.A.P. is for his continued cooperation with DHS. Well, I fail to see the injury. This is not an administrative probation.
As long as you don't see an injury, then they can do what they want.
Absolutely not. It's entirely possible the court could overstep.
That's basically what you're arguing, that a case starts off as a juvenile, quasi-criminal, actually criminal matter, where a person is sentenced and placed on probation, and then all of a sudden the court says, well, I've had enough of you. I'm closing this file. I'm turning you over to Human Services, and you cooperate with them. Does that seem to follow any of the statutes in this case?
Your Honor, that is exactly what the legislature provided for. Exactly. If you look at the statutes, 2521B3 and 2552, A and B, you believe
that you can commingle the PENS procedure with the juvenile delinquency procedure?
Well, that's not me, Your Honor. That was incorporated by the legislature under 2521B3. You can see it there yourself. The legislature gave wide latitude under the child's policy for the family court to do exactly what it did here. And second guessing the family court's decision could lead to a slippery slope of juveniles coming before the court saying, complaining that the family court abused its authority when really, this is all for the benefit of the child and the community. And the court followed the appropriate procedures. A.A.P. was given a mid-probation review hearing at which he was allowed to object to any of the court's findings. He was allowed to cross-examine Jocelyn Smith, A.A.P.'s social worker, he called his own witness. So I fail to see how he was denied any due process. The court, again, in the midst of a pandemic, chose not to have a final review hearing after already holding a dispositional hearing and a review and receiving nothing from A.A.P. to suggest that he complied with the court's June 30th dictate from the bench.
Don't you think there should have been a final review hearing if her intent was to close the case and place the minor under the supervision of Human Services so that the minor could then defend against the action of the trial court?
Well, Your Honor,
hearing in that instance?
Your Honor, the statutes don't provide for that. The court followed the statutes, and whether there was a final opportunity, he did have an opportunity.
Do the statutes provide for a revocation of the probation?
Again, this wasn't a revocation. This was not a revocation.
Because no complaint was ever filed. So how did he end up?
No.
How did he end up out of the probation under Human Services supervision?
Well, to address the first issue, revocation means that the government is going to reinstate the original complaint without taking the adjudicated delinquent's plea and start fresh. Has that applied here because that's not what the government chose to do. It's the government's prerogative to file that complaint. The judge's prerogative to follow the statute.
That wasn't the government's request anyway.
It wasn't. And if you look at Attorney Christian or A.A.P.'s requested relief in this case, he's not asking for those probation revocation procedures to be followed. He's asking you to take that power away from the family court, the power provided by the legislature, take the power away from the DOJ through probation revocation, and just vacate the decision allowing A.A.P. to wander the streets without any supervision.
No. That's not my understanding, attorney. That's not what my understanding. My understanding is that I remember that Judge Christian had filed a motion because he was going off island to take care of some family business. And next thing you know, the case is abruptly closed, shut down, dismissed.
Correct.
So the judge not only closed the file or the case, but she had a provision on there that sent him over to Human Services that indefinitely make him stay in contact with the people over at Department of Human Services. If in fact that, as you say, all the government has to do is to file a new case. If in fact that he get involved in any other royal rumble or any kind of mischief or violate any laws after the case is closed, then the government has a right to come on, whether under a person need a supervision or whatever, and file a new case. But here we have a case that is closed, and the only reason why that he was before the court is because of this case that was closed. But now he has to follow the dictates of the Department of Human Services, and he doesn't seem to have any recourse. He can't object. He didn't have a chance to object.
Your Honor, in my final minutes, I would just say that I would caution this court away from rewriting what the statutes say. The probation revocation procedures of 2525 do not apply here. The family court was within its authority, and I think that this was all in the best interest of the minor A.A.P. and the community, which is the family court's purview. So I would be reluctant to second guess it.
What is in the best interest of the minor? What is the best interest of the community? But what we are simply saying is that, that when you're going to do something that involves minors that have attorneys and whatnot, that the least you could do that, always give them an opportunity to be heard.
And one last note, Your Honor, it was not indefinite. There is a temporal limitation provided by statute.
But he reached maximum age. Okay.
Yeah, right.
It is a limitation.
Well, that's what I say. It's indefinite until he reached the age where he is no longer he's no longer
a temporal limitation.
Jurisdiction of
Okay,
the court.
thank you, Attorney Francisco. Attorney Christian, you've got 5 minutes. You reserve. You may proceed.
I apologize. I muted myself while Attorney Francisco was speaking. Thank you for this opportunity. A couple of things. The injury is very clear. The minor has the right to be free and live in society without any undue government interference. Once he pleaded delinquent, he did forfeit some of that freedom, but only within the confines of the processes provided by the legislature. And the family court did not follow that procedure. There is no authority to place a minor under the supervision of the Department of Human Services and close a case. Counsel's reference, well, first of all, I would point out that in response to the motion for reconsideration below, none of these statutes were cited by the people. They did not raise any of these arguments, only the argument that there is some broad-based authority for the family court to do what's in the best interest of the child. So all of these other arguments are waived. To the extent that the family court does have broad authority, that broad authority must be exercised within the confines of the proceedings for juveniles spelled out by the legislature. Within those confines, the family court has very broad authority. Outside of those confines, the family court has no authority. And that's what happened in this instance. The references in 2521 of Title V, that section speaks specifically to the authority of the court as a result of a disposition hearing. The August 17th order and opinion are not the result of a disposition hearing. They're not the result of any hearing at all. The court simply took the report of Human Services issued a month and a half after the previous hearing and the court made certain findings that the minor was still delinquent. This court has made clear in the Boynes case, in Riera, when a court is going to make findings based on facts that have to be found, there has to be a hearing. And there was no hearing here. The court simply made a decision based on the essentially a hearsay statement of the Department of Human Services. In addition, the reference to 2552, if you read that statute, that is clearly designed to give the court the authority when the requisite grounds are presented and found to issue orders to other people who are causing the minor to be at risk. It doesn't give any authority to order the minor, him or herself, to do anything. So that section has no applicability here. Simply put, what has happened here is the family court exceeded its authority. It violated the due process that A.P. was entitled to have. It violated his liberty interests, and the order must be vacated. With respect to the reconsideration, whether it's viewed as a reconsideration hearing or a motion for relief under 60B, relief is warranted because, one, as to reconsideration, there was clear legal error. As to 60B1, there clearly was surprise. There's nothing in the statutes that would put A.P. or his counsel on notice that being placed under the supervision of DHS was an option. And the court—
was the court asking DHS to do anything that it wasn't doing?
Yes, because DHS's authority to monitor the conditions imposed by the court under 2521 and 2524 only exist within the confines of a court case. Once the court closes the case, DHS has no independent authority to continue to monitor minors. Minors, just like adults, have rights to be free. That's their liberty interests. And so when those interests are going to be infringed upon by the government,
doesn't DHS have the authority basically to provide support and services to families with extreme and chronic dysfunction or at high risk? And isn't that basically what the court did when in closing this case and referring him to Human Services?
Human Services has a host of offerings that it can make to families in the community. And what happens in those instances, the families go to Human Services and say, Human Services, please help us. When it comes to being ordered under Human Services—
Can Human Services be the complainant? Can they be the aggressive person and go and say, we need to have control of this person?
They are authorized to do so through the Department of Justice. The Human Services goes to the Department of Justice and says, this minor is in need of supervision, or this minor is being neglected or abused. That's how that process starts. But that's a whole separate proceeding from a juvenile delinquency proceeding. And those proceedings were not initiated.
And the hearings that the court had, they didn't learn enough to really make that determination that this person was testing positive for marijuana, and he didn't complete his community service, that he was out on the street after his curfew. Wasn't that enough to kind of conclude that this was a dysfunctional situation and act accordingly?
Well, the way that's set up in the code, that's not for the court to decide. It's not for the court to initiate custody or abuse and neglect proceedings or PINS proceedings. The code specifically requires a complaint be filed by the Department of Human Services, by the Department of Justice acting on behalf of the Department of Human Services. For the court to initiate it on its own, then you end up having a separation of powers issue, because the commencement of those proceedings is an executive function, not a judicial function.
Okay, thank you.
All right, thank you for this opportunity, Your Honors.
The matter is submitted, and we will
Thank
proceed
you,
to the.
Honors.
Thank you both.
May I be excused? I have no further business.
Yes, you all both may be excused.
Thank you. Have a good day.
Thank you, Your Honors.
Well, we'll proceed to the final matter, which is the TVA versus Lockheed Martin et al. Prime versus Lockheed Martin et al. And Weeks. And this is numbers 35 of 2020, 36 of 2020, and 37 of 2020. So for the appellant, do you wish to reserve some time, Dr. Johnson?
Yes, Your Honor, 5 minutes, please.
Okay, 5 minutes. And you'll be arguing on behalf of all three?
Correct, Your Honor.
Very well. You may proceed.
Mr. Chief Justice, Associate Justices, and may it please the Court, Jacob Gower on behalf of the appellants. The Superior Court erred as a matter of law when it concluded that a Rule 25 motion to substitute is not subject to the tolling components of Rule 6B1 of the Virgin Islands Rules of Civil Procedure. If the Superior Court's decision stands, then the Virgin Islands has retreated to pre-1963 jurisprudence, particularly the Anderson decision, which the Superior Court noted was based on one of the worst rules of civil procedure. And that's the form of Federal Rule 25, which was incredibly unforgiving. Under this modern version of Anderson, no amount of good cause or excusable neglect can ever resuscitate a case when substitution wasn't perfected within 2 years. It matters not whether the heir is incapacitated. It would matter not whether or not the heir is a minor. It wouldn't matter if the heir doesn't know of their relative's passing. It wouldn't matter if the heir doesn't know that their relative had a lawsuit or had any patrimony. It wouldn't matter if the heir doesn't understand or know about their obligations to timely substitution within 2 years. It wouldn't matter whether or not the heir is represented by counsel or lacks any legal education, as if they were proceeding pro se. And then focusing on the particulars of this case, it wouldn't matter whether or not there's been any appreciable action in the litigation in more than a decade. For example, it wouldn't matter whether or not a case management order had entered. It wouldn't matter whether or not the litigants have been waiting for rulings on dispositive motions for more than 6 years. Ultimately, Rule 25 doesn't compel this result. It wouldn't compel any of these results. Rule 6B1 offers a clear opportunity for the court to be able to step in and exercise its equitable authorities upon the proper showing to the court of equitable good cause.
Would it matter if to commence the case in the first instance on the 2-year statute of limitations, would any of those things matter if a person didn't file it within 2 years? And ask the court to extend the statute?
I don't know if I fully understand your question, Your Honor. Are you talking about?
My question is, you said, my question initially in starting the case, would any of those things, whether a person was a minor, would those matter if you didn't file it on time?
I think in the instance of incapacity and being a minor, I think it would. I don't think the statute of limitations would run in that instance. I also think that, as this court, or at least the Superior Court has made clear, is that the Virgin Islands, the sound rule for the Virgin Islands is to recognize that there is things like class tolling, there is the discovery rule, there are equitable exceptions to traditional statutes of limitation. So, yes, Your Honor, some of these things.
My question is, why isn't 2 years after the death of someone sufficient? And if 2 years passes and there's no substitution, why isn't it just as fair as when you have the obligation to commence the case initially within 2 years?
Well, I think that the situation here is, Your Honor, let me put it in the specific context of Ms. Khan. Ms. Khan didn't know that her father had a lawsuit. And so there was no real opportunity from her perspective to step into the shoes of her of her late father and to be able to take over the reins of that case. It was only after about 2 years, 6 months or so that, Attorney Alcon, who was representing her late father prior to his passing, made contact and sort of that connection was made, and then a motion was filed. In that case, it's just simply she wasn't aware of the 2 years and didn't know that any action was necessary to preserve that right.
Well, your argument is that the Rule 6B, we're trying to use Rule 6B to extend the time limits that have been imposed by the statute. Isn't Rule 6B usually used to extend time limits that are imposed by other rules?
Yes, Your Honor. So Rule 6B would be enlarge the time for something that's subject to, one of the other rules that's in the Rules of Civil Procedure. We've operated from the presumption that Rule 25 operates not necessarily to the exclusion of Section 77 and Section 78, but Rule 25 was the operative provision by which the plaintiff or the appellant sought relief before the Superior Court. So it was a rule-based action rather than a statutory-based permission that was requested.
But if the rule is identical to the statute, can you basically get around the statute by going under the rule?
Maybe, Your Honor. And I think that the discrepancy here is that this court, as well as the Virgin Islands legislature, have the concurrent authority to engage in rulemaking. And I think Judge Willox aptly notes that in the Jones decision, where he talks about the history of the Revised Organic Act. So I think this court, though, could recognize that it is engaging in a concurrent rulemaking authority, but there really is no conflict here. If you look at Section 78, it includes both a substantive component and a procedural component. The substantive component says that your cause of action doesn't expire at death. The second part of that is really a procedural aspect. It doesn't read like a traditional statute of limitations, but it reads like procedure. And the history of that rule is somewhat important insofar as if you look back to whence that came, back to Oregon and Alaska, these were seen as rules of procedure that predated sort of the actions, the actions that many courts took subsequent to that to create their own rules of procedure. Procedural rules, but back in the day, many times were enacted by legislatures. But at the bottom, I think the court should not really see that there's a conflict between the two, that there is a clear resolution. It need not choose one or the other. But dismissal is not compelled by the statute, ultimately.
How about this case, this court's case, Hodge versus McGowan, where the court basically said that substitution had to be brought within the 2-year period?
Correct, Your Honor. So the dichotomy of the issue that was being resolved in Hodge was whether or not to apply the local rule or the federal rule. And so in that case, you were looking at Section 78 versus a federal statute. The court was not confronted with the current language of Rule 25. That's the first part. Second, no motion to substitute was ever filed in Hodge. Even after the decision, even on appeal, no motion was ever filed. And then most critically is that Rule 6B is never addressed squarely by this court in Hodge. And as Judge Malloy and Judge Willox both recognize, is that this court did not squarely confront that issue in Hodge, mainly because it wasn't brought to this court about whether or not 6B has any role to play in a late substitution. Your Honor, I want to kind of redirect our attention to what we think that the major issue is, and that's the 6B analysis was not fairly or faithfully followed, or the 6B procedures and factors were not faithfully followed by the Superior Court. And so I'd focus the court's attention to specifically to paragraph 45 of the opinion from the Superior Court, where it recognized that if good cause were a factor, then Tamika Khan, the appellant in Mr. Weeks's case, may have shown it. But just 3 sentences later, the court then concludes that 2 years is enough, and 5 sentences later reiterates that Rule 6B1 doesn't apply. So for the remedy, what we ask for is a remand to the Superior Court with instructions to take the rubric of 6B1 the 6 to 8 factors that it enumerates, go through each of those one by one, have an evidentiary hearing where all of the facts may be adduced on the record about why substitution did not happen within 2 years. And if the appellates lose, the appellates lose. But at least there's a full exposition of all the various factors and at least an effort to try to resolve these cases on the merits rather than a procedural defect, as we would characterize that view.
So you're basically asking us to disregard the holding that the 2 years is basically like a statute of limitations, and we should, and the judge actually so concluded, and then just went on to say, well, assuming that it wasn't a statute of limitations, and that the procedural rule applied, so he could consider the motion. So he just asked us to disregard that, stick strictly with the rule, and require a hearing, basically.
No, Your Honor. So what I'd like you to do is just faithfully follow 6B1. 6B1 says that you can enlarge the time except for enumerated exceptions. Rule 25 is not an enumerated exception.
And you believe that those exceptions are, cut and dry, and there's no room for expansion?
I think there would be room for expansion if there was a clear textual commitment in some other rule that says you can't, this is a hard and fast rule, it's a statute of repose. For example, Your Honor, if I may indulge with the time of passing, former Rule 6B1 specifically carved out Rule 25 motions. That rule was changed back in 1963. That provision was specifically excised. So when this court had an option of what 6B1 sort of iteration it could choose a specific Rule 25 carve out, or it could choose a provision without a Rule 25 carve out. This court deliberately chose the modern statute that does not carve out.
The carve out was a totally different rule, though. That was a rule that says, you had 90 days basically to substitute.
No, I'm not talking about the federal rule of substitution, Your Honor. I'm talking about the federal rule 6B1, or the federal counterpart to Rule 6B, not the substitution provision of Rule 25. You're right, Your Honor. I don't want to take the court down that rabbit hole, but Rule 6B,
when it carved out 25, at that time the rule was a very strict rule, correct?
Correct, Your Honor, it was.
Okay. All right, thank you. Attorney Johnson?
Good.
Just for the timekeeper, you will be arguing for 10 minutes.
I'll be arguing for 10 minutes total, Your Honor, and I'd like to reserve 4 minutes of that time for rebuttal.
Okay, who are you representing?
I'm representing Lockheed Martin Corporation, Justice Hodge.
You get rebuttal?
I do get to reserve.
I didn't think that the appellees get rebuttal.
I did think I got to reserve time, Your Honor.
What?
I did believe I got to get to reserve time, Your Honor, to respond.
As an appellee? I don't think.
Well, that's what I was requesting, but if the court will require me to give all the time up front, I have no problem with that either.
Yeah, you have to, because you only get to argue once as the appellee.
Understood, Your Honor.
So you may proceed. We'll give you 2 minutes as usual.
May it please the court. As a threshold matter, the notice of appeal in this case was filed out of time. The court's order, the memorandum of opinion of Judge Malloy, was issued on April 26, 2020, and the notice of appeal was filed on May 29th, 2020. So I'd like to raise and preserve that for the record for the court, as jurisdiction, of course, can be raised at any time. And that, of course, is in violation of Rule 5 of the VI Rules of Appellate Procedure.
And did you raise that below?
We did not raise it below, Your Honor, in preparing, but jurisdiction, of course, can be raised at any time, and so we are raising it now. These are not cases of near misses. These are cases of extreme inexcusable neglect. In this case, the court heard all arguments on these motions, and there were no facts in dispute. Appellants don't argue that the motion for substitution were filed at a time. Lockheed and Glencore timely opposed. There's no argument that substitution of a deceased party must occur within 2 years of death. This court in Hodge versus McGowan held very clearly that substitution of a deceased party must occur within 2 years. If Section 78 of Title V is reviewed like a statute of limitations, as the court held in Jones versus Lockheed under Judge Willox and Martin versus Hoventa under Judge Malloy, then there is no discretion in the statute itself to determine or consider good cause or excusable neglect. Moreover, the statute is in derogation of the common law. At common law, all personal injury or tort actions abated when the person died. Statutes that are in derogation of the common law must be strictly construed. And in this case, as the district court held in Richards versus Nolan Associates, relying on Hodge, there is no discretion to consider good cause or inexcusable neglect. What the appellant is asking is for an evidentiary hearing where there are no disputed dispositive facts. That would result in a slippery slope. Every single motion for extension of time, for a late motion, for a late filing, would be entitled to an evidentiary hearing on the record. That is simply an absurd result that would be completely inefficient for the court and clogs the court's docket. Additionally,
Where it requires specific.
Attorney, I have a burning question.
sure.
Do you recall when the Virgin Island Rules of Civil Procedure went into effect?
2017, March 2017.
And that would be after our opinion in McGowan, am I correct? McGowan was done in 2008.
Correct, Your Honor.
Correct?
Correct,
Okay,
Your Honor.
November 10, 2008. Well, look at it this way. So the Virgin Island Rules of Civil Procedure came into being after McGowan, and the Rule 25 talks in terms of the substitution of the parties. And I noticed that the language in that use a lot of may, M-A-Y. A motion for substitution may be made by any party or by the decedent, successor, or representative. The motion may be granted at any time within 2 years after death. All right. Well, we have that Rule 25, but look at what Rule 6 did. Look what Rule 6 did. Rule 6B1, and I think that the plaintiff them made us a good argument when they said that because it says the court may, upon a showing of good cause or excusable neglect, extend the date for doing that act. The court may consider whether the request to extend the time is made before or after the required date. The reason for the movement's delay, whether for the reason for delay was within the reasonable control of the movement, and then it sets out all these things. And then they get to the crucial thing here where they have the exception. And I believe that plaintiff's attorney made a strong argument where the rules set out to say what rules are accepted from Rule 6B1. And he's absolutely correct that the Rule 25 substitution of parties is not included. If it's not included or excluded, couldn't the argument be made that that was not just a fleeting or inadvertence or happenstance, that it was a deliberate thing to make an exception? Where are you going to make exceptions? And you have Rule 50B, 52, 59, and 60B. That go to old-fashioned 60B. You made all of those rules exception to Rule 26.
Let me interrupt really quickly, Your Honor, there. Your Honor, very critically with this opinion, and this is why this opinion in part is so brilliantly written, is that it's not only about Rule 25. The legislature codified 5 VIC Section 78. There is a statute. There's a statute at play, and Judge Malloy's opinion incorporates both. To say that the Rule 6B now provides discretion where the statute does not, right?
Yeah,
and the legislature essentially determines
but you see,
the court's jurisdiction.
The statute.
Be very careful,
if you will
because the court, because for all intents and purposes, the statute 5 VIC 78, yeah, I know it talk about substitution of parties. Then what you're simply saying is that which one would take precedent in a case like this? Is it the rules, the Virgin Island rules of civil procedure, Rule 25 and Rule 26? Or do we say that we cling tenaciously to 5 VIC 78, the substitution of parties, where it says that in the case of death or disability of the party, the court may at any time within 2 years on motion allow the action to continue or against a personal representative or successor in interest. So then what you're saying then is that if we're going to have that, then we don't need a Rule 6.
Well, what I'm saying is that the statute says what it says. The statute says,
the
statute says 2 years.
upshot of that is that if you cling tenaciously and go with 5 VIC 78, then there could never be a substitution beyond within the 2 years,
Well,
which were not the intent of the Virgin Island rules of civil procedure.
there could, under certain narrow circumstances, and Attorney Gower raised that in his direct, such as equitable tolling. But equitable tolling hasn't been argued in this appeal.
Attorney Johnson, I just was about to ask you that. If it's a statute,
Yes.
you were just about, I think, to address the point that I was going to ask you about. If it's a statute, the statute would require the court then to interpret the statute. In other words, it would require statutory interpretation. The result could be then equitable tolling, would it not?
It could be, but equitable tolling has a standard that hasn't been argued here. And in equitable tolling,
I understand that.
Yes.
But you brought up the statute, or you're saying the court didn't have any discretion. The rule, however, is very, very similar to the statute. If the statute can be tolled equitably, why can't you have the same flexibility with the rule?
well, for one, the statute would govern, and that has been our argument from the beginning. The statute hasn't been repealed. The statute essentially works in conjunction with the rule. It's sort of belts and suspenders. The statute was designed to be congruent with the rule.
How do you respond to your counsel's argument that the statute is part procedural and part substance? And the substantive part, he says, is that the death of a party does not suspend the case. The case continues. And the procedural part is that you got 2 years in which to do it. And the law that this court has decided and was followed by 2 judges on the Superior Court he mentioned, that says that where there is a procedural matter and the legislature have spoken on the procedure and this court has spoken on the procedure, that this court's pronouncement will prevail. So if in fact that portion is procedural and Rule 6 has been adopted by this court, governing the practice and procedure which this court is authorized to do, why wouldn't that rule control?
I agree that the court has the discretion to determine procedurally whether it can be told or not, right? I do agree with that. But my argument is that the weight of case law provides that tolling comes in a context. And that tolling here is equitable tolling. And let me add one other thing, Your Honor, because I see my time is lapsing. In addition, this case considered both excusable neglect and good cause. In Metivier, the court, even though it didn't have to, went through an analysis and determined that the motion for substitution that was filed over 5 years later, that there was no good cause for it. That Metivier had lost contact, that the counsel had lost contact with the widow, and that there were other means for the plaintiff's counsel to communicate with the family. Very similar in Weeks. In Weeks, Tamika did not argue good cause, and the court ran through how the substitutor didn't argue good cause and waived good cause in her initial motion. Very similar in Prime. That involved a 10-year delay when the motion for substitution was filed almost a decade after the death. So even though that Rule 6 didn't apply and excusable neglect wasn't a part of the analysis, a required part of the analysis, the court still went through that process and found that it was just simply not good enough.
But the court relied specifically on the length of time, correct? And
Not at all. In some, there was the question of waiver, right? because and that goes back to very fundamental principles where in one of the cases, for example, the substitutor failed to disclose that the date of the death. And the court noted that it seemed like they was trying to sort of mislead the court and then failed to raise it on their initial briefs and only raised it on their reply, thereby waiving that argument. Later upon that, Your Honor.
Then the court also said, well, he didn't even have a client, so therefore he wasn't even the attorney in the case. So, I mean, how can you have it both ways? You know?
Well, part of it is this. That one of the things that Attorney Gower argued is how bad Rule 25 was. But that Rule 25 under the federal rules only gave 90 days. All the case law below, case law in other jurisdictions that holds that there's a 2-year period,
but
cases can't be interminable.
90 days from suggestion of death on the record. You know, whereas here, there's never been a suggestion of death on the record. Correct?
Well, the rule doesn't require, this rule, as a matter of fact.
I know, but you're referring back to the 90 days.
Rules does.
But the 90 days,
Your Honor, is that this rule is so permissive. Under the old rule, a probate estate had to be opened up. This rule requires a 2-page motion. That's a very low standard in a very long time. There has to be a point where these cases, like all statute of limitations, are honored and end. Otherwise, they can go on forever.
okay, thank you.
Thank you.
And your co-counsel?
Oh, yeah,
Morning.
Attorney Hunter? Yes. You have 5 minutes, so you may proceed.
Okay, thank you, Your Honor. I represent Glencore in the Weeks case only. I'd like to point out in the Weeks case, as well as apparently in the other two, the notice of appeal was not filed within 30 days of Judge Malloy's dismissal of the case on April 26, 2020. We rely on Hodge versus McGowan, Sweeney versus Hombres, and Richards versus Nolan and Associates with respect to the 2-year period after date of death of a litigant for substitution. It's our view that Rule 6B cannot amend the statutory 2-year period that is in Title V, VIC Section 78. And the argument presented by the appellant that you need to cut that statute in 2 halves, one substantive, one procedural. I disagree with their characterization as the provisions of the 2-year period being a matter of procedure rather than substance. We believe that an evidentiary hearing was not required here. There was a hearing on the motion, and I don't believe that there was another request during that hearing for an evidentiary hearing, although it was requested in the initial motion, in the second motion that was filed by the appellant in the Weeks case. With respect to the requirement of an evidentiary hearing, we rely on Rivera Marino and on 3RC and Company versus Poins Trucking. I think a critical issue here, Your Honor, that is dispositive of the Weeks appeal is that it is clear from Judge Malloy's written opinion, which is extremely thorough, that he...
Let me just ask you before you,
Yes.
so we can get this timeliness issue out of the way. During this period, was there administrative order issued by this court that extended the deadlines to 6/15?
I recall there were orders extending deadlines, Your Honor, and I haven't checked the
Did you
applicability.
check those?
I haven't checked it.
All right, thank you.
Yes. All right, so turning to Judge Malloy's opinion on Joint Appendix pages 31 and 32 in the Weeks case, it's clear when you read through this, when he discusses this case, that he assumed the truth of the affidavit filed by the appellant as an attachment to the motion to substitute the estate. So if there's no factual issue in dispute from the perspective of the court, there's no need for an evidentiary hearing. And the appellant has the burden in this appeal, Your Honor, in the Weeks case, to show that Judge Malloy abused his discretion under Rule 6 in denying an extension of time and abused his discretion in evaluating the facts that were asserted by the appellant and which he assumed was true.
But did the judge make findings of fact in which he determined that good cause wasn't shown?
Implicitly, he did. Yeah, he said that.
So did the parties have a chance to rebut those, or to at least to put on something on the record that would counter those?
Well, the only party that had a chance to put something on the record was the appellant, and that was by way of an affidavit and the motion that was submitted. My client, the appellee, had no specific knowledge other than what was put forth in those documents.
And that is all that was before the court as well, correct?
That is correct, Your Honor. And the court held that that was insufficient to establish good cause, and his findings are on pages, appendix pages 31 and 32. He pointed out that Ms. Weeks did not give a time frame for when she reached out to Attorney Rohn's office. He pointed out that she did not make any effort to reach out to either the Superior Court Clerk's office or the Supreme Court Clerk's office to determine whether any case was pending. He pointed out the insufficiency of what was pled and asserted, and he assumed the truth of that, and he said this is not enough. So I think the appellant fails to meet the burden that it has of showing an abuse of discretion requiring that Judge Malloy's opinion be reversed.
Okay, thank you.
Thank you, Your Honor.
Mr. Dahl? You may proceed. You're muted, so it's unmute.
Just wanted to take 2 seconds here to thank the court for the opportunity to speak to you today. It's my first opportunity to appear before the Supreme Court. Got 2 small issues here. One with regard to what the appropriate standard of review is. In the notice of appeal and the way that it's been briefed to the court, appellants specifically couch this in terms of an abuse of discretion. Certainly, as if Attorney Hunter describes the appropriate standard as one of abuse of discretion. I'm sorry, we've couched it in terms of legal error. If the standard is one of abuse of discretion, then very well, the appellants may not have made the appropriate showing. However, if you look at the court's decision and how truncated it is, specifically when you're looking at paragraph 45 and the various factors that are outlined by Rule 6b1, it's quite clear that the Superior Court didn't undertake the sort of fulsome analysis that 6b1 prescribes. So these are all permissive factors, but it lays out about 8 different things that you can consider. And Judge Malloy abruptly truncates it and says, look, I think this, as a legal matter, it's game over after 2 years. I don't need to really go into the broader analysis. I think from this court's perspective, I think that the safer route is to find that this is a legal error rather than a ruling on the facts, and give it another opportunity on remand to see if we can't get this out the right way. The second thing, I want to note the big differences, the crucial differences between Federal Rule 25 and the Virgin Islands Rule 25. And appellants are not asking this court to rewrite the rule. The federal court rule is written deliberately, and so is the Virgin Islands court. They're very different in their approaches. But there's one critical thing about the federal rule that's different from the Virgin Islands rule that sort of facilitates or would lead to these sort of inequities that I addressed at the outset. Under the federal rule, you have 90 days to seek substitution. And it's from the time that there's a notation of death on the record, but that doesn't end it. There's also an obligation for that notice of death on the record to be sent out to the heirs, to the people that would be the successors in interest. And so in this example of Mr. Tamika Khan or Mr. Prime or Mr. Mativier would need to be put on notice that there is a filing in the Virgin Islands Superior Court, that there has been a notice of death, and that they have 90 days to take some sort of action. That's a big distinction. There's a stopwatch running based on the record that's before this court. And when you don't know the stopwatch is running against you, you don't, it's tough to be able to act timely when you don't even know that that stopwatch is there. But also I want to draw out one final critical distinction here, is that in the federal Rule 25, it says that the motion shall be filed within 2 years. And it goes a step further than the Virgin Islands rule. It says if you don't act within 2 years, the case shall be dismissed. And it's not permissive language as Rule 25 is in the Virgin Islands or Section 78 is. It's quite mandatory. The action must go away. However, as the District of the Virgin Islands has said, is that even in the federal system, the federal Rule 6b is not so unforgiving to completely take away any sort of equitable outcomes or equitable options. Even in the District of the Virgin Islands, even if you miss your mandatory 2-year window under Rule 25, you still have an opportunity to make a Rule 6b showing. So at bottom, Your Honor, I think that I want to come back to the remedy that we see.
Attorney,
Yes,
there's something that I noticed because you're making a comparison between both Rule 25s. I noticed something after looking at our Rule 25 so many times. And if we read it, it says if a party dies and the claim is not extinguished, the court may. Look at that word may, because it becomes crucial later on. May order substitution of a proper party. A motion for substitution may be made by the party or by the decedent, successor, or representative. And then the last part is what caught my eye. The motion may be granted at any time within 2 years after the death. So if they said may, does that may in that last sentence of Rule 25 allow Rule 6b1 to seep in and for us to consider for good cause shown, as opposed to over in the federal rules where the last part is said that the action by or against the decedent must be dismissed. Does because of the language, this may in our Rule 25, the Virgin Islands Rule of Supervision, does that allow Rule 6 of our Virgin Islands Rules of Civil Procedure to seep in under for good cause shown when and then since that it allows it that rule and further on that the substitution, the issue of substitution is not covered in under the exception under Rule 6. So that makes a difference as opposed to must over in the federal rules.
I think it does make a difference, Your Honor. I want to kind of switch things on you though. Rule 6b1 says you can do it. Rule 6b2 says there's certain things you can't do. And the only other exception that would be possible is if there was a clear textual commitment in Rule 25 that says you also can't do it here. And there's nothing in here that would say you can't get 6b relief under Rule 25. And may I address just real quick the absurd result that might happen. Let's say that 1 year, 11 months, and 25 days goes past and a motion to substitute is filed. Under just a very plain reading of this, if that motion is, if the judge sits on that motion for 8 days, substitution is not proper.
Right.
So we got to be kind of careful about how we read the may.
All right, but look at this, attorney. Basically, so what I understand is that because of the language of our Rule 25 and our Rule 6, it seems to have a lot more saving grace because of the may language used there than under Rule 25 of the federal rules. The federal rules, you are truncated, you are cut off because the case is dismissed. But was that a basis, was there a reason why when we read our Rule 25 and Rule 26 and the language of may as opposed to must over in the federal rules, does it allows I wouldn't say derelict, but a tardy plaintiff's representative, successor, or whatever to come into court?
Short answer, yes, Your Honor. I think it is more forgiving in the system in the Virgin Islands, and that's appellate's position is that remand and get the standard right before the Superior Court is the way to go.
Okay, thank you. The matter will be submitted. Thank you all for attending. That concludes today's calendar.